My name is Adam Burke. I'm a lawyer in Columbus, Ohio. The purpose of this video is to talk to you about felony drug charges, in particular penalties associated with felony drug possession. This isn't a discussion about other states' drug charges or penalties, and it's not a discussion about federal drug trafficking or federal drug charges in general. It's a discussion about Ohio penalties for primarily felony drug possession charges. There's a pretty substantial overlap for the most part, especially on the higher ends of drug quantities and more significant felonies between possession and penalties. But for our purposes, we're talking about um, today possession rather than drug trafficking penalties. In future videos, I'd hope to get into a discussion of all the different types of penalties for the different drug abuse charges. But the way Ohio law works is that with the exception primarily of marijuana, most drug possession charges land a person in felony court. So we're going to talk about what constitutes a felony drug charge versus what's a misdemeanor drug charge. And with respect to marijuana, there's a wide range, but the focus on, because of the nature of these charges, the focus of this video is going to talk about primarily felony drug possession penalties, and then at some point down the road, I'm going to have some more videos that talk about suppression issues, how to suppress evidence, some other videos about alternatives such as diversion, drug court, intervention in lieu of conviction, these are some options for people that can hopefully avoid the possibility of even having to face even the potential of prison time, which is unfortunately the nature of drug charges, is the reality that there is in general in Ohio, potential for prison time. And the one exception to that would be for low-level quantities of marijuana, which are considered minor misdemeanors and are non-jailable offenses. But having said that, the way Ohio law works in terms of felonies is the more serious felonies are deemed to be first-degree felonies. So things like murder, rape, robbery, most robberies tend to be first-degree felonies. The lowest level felonies are the fifth-degree felonies. And so sometimes shorthand we say that the first-degree felony is called an F1. Fifth-degree felony is called an F5. But the most serious felony that a person can face in the state of Ohio would be first-degree felony, which can lead a person to face a potential penalty of 3 years in prison up through 11 years in prison. There's also potential for a $20,000 fine. The next tier down from that is an F2 or a second-degree felony, and I'll be abbreviating felonies as instead of a second-degree felony, I'm just going to say an F2, and that's the number 2 obviously corresponds to the level of the offense. So for an F2, the maximum possible penalty is 8 years in prison with a $15,000 fine. For an F3, the maximum possible penalty is 5 years in prison and a $10,000 fine. For an F4, the maximum possible prison sentence is 18 months. And then for an F5, the lowest level felony, it's up to 12 months in prison. There's a minimum of 6 months if the judge decides to send a person to prison on an F4. So that's what we're talking about in terms of penalties on felonies. Now, each drug, because drugs are manufactured differently, they have different effects and are quantified differently, the court system actually kind of delineates out different penalties for different quantities of different types of drugs. For example, cocaine, if a person is found to be in possession of less than 5 grams of cocaine, that would start the felony level out at a fifth-degree felony. And for example, on an F5, fifth-degree felony, a person's looking at a potential prison sentence of up to 12 months, although the lower level felonies for somebody that's not a career offender or doesn't have a long record, oftentimes what we can do is look at alternatives like intervention in lieu of conviction, sometimes drug court. So there are paths to divert people for low-level felonies in particular for drug charges that we hope to get those people in particular, we hope to get everybody some help, but in particular, folks who've had no limited or no record, we have a better chance of being able to intervene with things like intervention in lieu of conviction, which is basically probation, some treatment, and then hopefully a dismissal at the end of that probationary sentence. The next level up on an F4 is 5 to 9 grams of cocaine possessed is a 4th degree felony. 10 to 19 grams is a 3rd degree felony. 20 to 26 grams is a 2nd degree felony. And then more than 27 grams is a 1st degree felony. Heroin is measured in two ways, either by grams or unit doses. I'm going to just stick with the grams for the most part, but just by way of illustration, a person that's caught with less than 1 gram of heroin is going to be facing a 5th degree felony charge. But that the unit doses of heroin, if a person is caught with 10 or less unit doses, the person could also be charged with a 5th degree felony. So again, I'm going to stick to the grams as opposed to the unit doses, but a person in possession of anywhere between 1 and 4 grams of heroin is looking at an F4 charge. Between 5 and 9 grams of heroin is an F3. 10 and 49, between 10 and 49 grams of heroin is an F2. In Ohio, 50 to 249 grams of heroin is an F1, and then 250 through any higher amount is going to be an F1 as well. And the reason between the separation between 249, which is an F1, and 250, which is also an F1, anything over 250 includes the potential, at least for something called a mandatory, or rather a serious drug offender specification. And what that does is it makes the maximum penalty mandatory if a person, in addition to being indicted on an F1, has a mandatory drug penalty of the maximum penalty. So you can be indicted for both, the quantity of the drugs, but then the prosecutor through the grand jury can attach something called a specification, and it's called a major drug offender specification, MDO for short. Can lead to a person being charged with or face a maximum penalty, which in the case of an F1 would be 11 years in prison. So that's a very dangerous thing for a person that's facing drug charges to be facing the possibility of 11-year mandatory minimum penalty for that high quantity of drugs. LSD is measured by doses primarily. So a person that has less than 10 doses of LSD is looking at an F5. Between 10 and 49 doses of LSD, that person is looking at an F4. A person with between 50 and 249 doses of LSD is looking at an F3. 250 to 999 doses of LSD is a F2. And then 1,000 to basically just under 5,000, or between 1,000 and 4,999 doses of LSD is an F1. Anything over that is a major drug offender specification. In addition to that, for marijuana is the one drug that there's some flexibility in the law that doesn't necessarily, it's less likely to start off a person being charged with a felony. So a minor misdemeanor quantity of marijuana is anything under 100 grams considered a minor misdemeanor. It's a non-jailable offense. Maximum possible fine is $150. So you can't go to jail for it. You can't have your license suspended. So a lot of people, just like any drug charge, can lead to the suspension of a person's license. So that's the real penalty for most people. Most people aren't worried that much about a minor misdemeanor charge. It's just like a taillight violation. But what is a serious charge is, a serious deal to people is losing their driver's license. Anywhere between 100 grams and 199 grams of marijuana is a 4th degree misdemeanor or an M4. Between 200 grams and 999 grams of marijuana is an F5. Between 1,000 and then 4,999 grams of marijuana is an F3. And then between 5,000 and 19,999 grams of marijuana is also an F3. But the reason those tiers of quantity are separated out between above 5,000 and below 5,000 is above 5,000, it's an F3, but then the maximum penalty on that F3 instead of 3 years is 5 years. So being between 1,000 and 5,000 can land a person a maximum of 3 years in prison, but then anything over 5,000 up through about 20,000 or just under 20,000 can mean up to 5 years in prison. And then when we're dealing with 20,000 grams of marijuana up through 39,999 grams of marijuana, that's an F2. And then anything over 40,000 is still an F2, but again, it's a major drug offender specification, which can lead a person to being faced with the maximum from the range, which on an F2 is 8 years. So anybody that's looking at over 40,000 grams of marijuana not only has to worry about the F2, but then also the major drug offender, which takes the minimum penalty or the mandatory penalty, takes that up to 8 years if a person's convicted both of the possession of that level of marijuana, and then also has a conviction for the major drug offender specification. So in some subsequent videos, I'll be talking about not just how the penalties are calculated, but I'll also be talking about how defenses are put together for these things. And when I talk about defenses, that could mean some alternatives to conviction, like intervention in lieu of conviction, like diversion, like drug court, but that specifically can also mean challenges to witnesses, such as chemists demanding the chemist's testimony, when that chemist report has to be made available before trial. We can also be talking about suppression motions on search and seizure issues, so we can challenge the admissibility of evidence depending on how that evidence was collected. If the search and seizure procedures used by police were lawful, if they were unlawful, then the law has a provision for that called the exclusionary rule, which says that the evidence has to be tossed. So even though we're talking about penalties, these penalties are by no means a foregone conclusion, and in subsequent videos we'll be talking about ways of working around those penalties and putting defenses together. And that concludes my video for today. Thanks for watching.